I think anyone who knows me would agree I'm a very strong-willed and stubborn person, so it's hard for me to admit that Mr. Bellisario had an impact on my life. I want to stand here and tell him that he hasn't had an impact on me at all, but that's simply not true.
Calling page 9, C-354165, State of Nevada versus Bradley Bellisario.
All right, this is our time set for sentencing. Are we ready to proceed?
The state is ready.
Mr. Bellisario is ready as well, Your Honor.
All right. Mr. Bellisario, this is the time set for entry of judgment and imposition of sentence. Is there any legal cause or reason why judgment should not be pronounced against you at this time?
No.
By virtue, pardon?
I just want to make sure I had sent you 2 batches of letters. I know that you're not at court today. I sent one last week and the week prior. The first one was about 100, including medical documents. And then I sent another one on Monday, which had more letters. I just want to make sure you did receive those before sentencing.
Okay. And all of those were put into the drive. Is that correct, TJ?
I believe so.
Okay. And I do have numerous documents that I've been reviewing, on the computer that my law clerk has been putting into the T drive for me. So I believe I have everything.
Okay. Have you had a chance to review them?
Yes.
Okay.
Yes. So, other than that, is there any other reason or cause we shouldn't move forward today?
No, Your Honor.
Okay. By virtue of your plea of guilty, I hereby adjudge you guilty of the offense of aggravated stalking, a Category B felony. State, any remarks?
Yes, and Your Honor, before I start, we will have only one victim speaker today. That speaker will be Brianna Lamana. Mr. Ellerman wrote a letter to the court that was attached to the original PSI. Ms. Bellisario and her child wrote a letter to the court that we forwarded to the court and counsel last week. I know the court's prepared for sentencing, so I understand that you reviewed those.
All right, thank you. Yes.
Your Honor, this case has a long and tortured history. It's been before this particular court for at least 4 years. I've only been the prosecutor on the case since October of 2021, so obviously my personal knowledge of this case occurred after that. But in looking at the underlying facts of the aggravated stalking case that's on for sentencing today, the state needed to point out a few details. In this particular case, the defendant was accused of violating a protective order, which is a court order that was put in place by contacting her family and her friends. She alleged that he was threatening, intimidating her during child drop-offs. And ultimately, at one point, when she's at a park with her small children, she receives a frantic phone call from a friend that she cannot come home because the defendant has gone to her house. And while she's watching on the Ring camera, she sees him ramming his vehicle into her garage, hitting her porch light, causing several $1,000s worth of damage. Ms. Bellisario became so concerned that she fled to her father's house, only for the defendant to show up at that residence and have to be held off at gunpoint by Ms. Bellisario's father because he wouldn't stop in violation of that protective order. And even after that incident, the behavior did not stop. He sent her dozens of threatening messages after that, which is the underlying cause of all of those protective order violations that the court can see listed throughout this case. But perhaps most concerning was in July of 2020, where he told her that he would kill her and see her in the afterlife. The court can see in the pre-sentence investigation report that the defendant indicates that these allegations occurred because of the bad relationship with his ex-spouse. He claimed that it was her conduct that caused his behavior, that it was her abuse that caused his behavior. But in reality, Your Honor, I think this case is replete with that not being true. The court can see that this defendant, despite these court orders of no contact, continued to violate them, followed her to her father's house to the point where he had to be held at gunpoint, and continued that threatening conduct to Ms. Bellisario. But it didn't just end with Miss Bellisario. In July of 2021, while that case was being prosecuted by the Clark County District Attorney's Office, the defendant sent a letter, an email to the assigned prosecutor on that case, Bianna Lamana. That case is 21 CR 048116. And pursuant to the guilty plea agreement and the fact that that case will be dismissed pursuant to negotiations today, Ms. Lamana will obviously have the opportunity to speak for herself. But I also needed to point out some facts of that case. The defendant sent her an email on July 30th, 2021, told her that he would be willing to settle the civil suit he'd filed against her. But he explained to her, given the county's refusal to help when I've contacted police, DAs, etc., and your insistence on perpetuating the lies of my ex that you know are false, I will be aggressively pursuing this matter against you. Please respond by Monday, August 2nd, 2021 by 5 p.m., or I will be filing a renewed complaint by and through hired counsel. I look forward to hearing from you. Good luck with your little one. As the court probably recalls, during that time, Ms. Lamana was pregnant with one of her children. And again, she can tell you how that crime actually impacted her, but I can also tell you that she had to take additional steps to ensure that the person who had spent much of 2020 threatening, intimidating, harassing, stalking Ms. Bellisario, she had to take her own steps to protect her own family, because if he was capable of doing that to his ex-wife, what was he capable of doing to somebody that he doesn't share children with? A new prosecutor had to be assigned as a result of that, of course, because now she's a victim of a case because of Mr. Bellisario. And obviously the allegations in the PSI were, my wife's abuse did this to me. She caused that behavior. But there is no possible explanation why in July of 2021, Ms. Bellisario's behavior would have caused this defendant to threaten a civil servant who was just doing her job. He eventually moved on to a new relationship with Risa Bhakta, which is the other case before Your Honor. It's the 446 case. And while that case or that relationship was in the process of ending, she was hanging out with a work acquaintance who was named Jason Ellerman. And he became the subject of the next aggravated stalking case. And he was the first time the state attempted to remand this defendant for his continuing threatening conduct. As the court has heard us argue many times about the facts of that particular case, I don't need to really belabor the point except to remind this court that while using a telephone associated with his law firm, he told Mr. Ellerman he was a lawyer with drug trafficking clients and he should enjoy the Colombian bow tie, bitch. Like, obviously, that's the second time I've had to explain that particular statement to this court, but it again shows that the conduct continued after the relationship with his wife was ending. So again, going back to the PSI where we're blaming his behavior, there is no possible way that Ms. Bellisario was responsible for that conduct in October of 2021. And that's when I became involved in this case, Your Honor. As the court can see from the PSI, this defendant also has two theft cases, one of which involved a minor that was determined and found right around this same time. That case is before DC 17, so we'll address the particular facts of that case in front of that judge. But there was another case that was unfortunately found a lot later, and that was the case in front of Judge DeMonte that's currently pending preliminary hearing. That case involved Elijah Lee. Elijah Lee was another minor whose mother had hired this defendant to represent them during this time. And the defendant utilized the money that was meant for Elijah Lee as a result of a car accident in his own personal expenditures. Mr. Lee became out $16,400. And if the parties can agree today, the state is amenable if the court will order $16,400 to Elijah Lee for that justice court case in front of Department 10. The state will be willing to dismiss that case as Mr. Elijah Lee will have been heard before this court. So we have years of conduct, and this case was pending for quite a while. And we just had the motion regarding the withdrawal of the guilty plea last month. And even during that time, we addressed the factors and the reasons why this defendant's behavior was concerning. But in May of 2024, well after these cases were all pending, this court saw behavior that was so concerning to it against another civil servant that this court remanded this defendant no bail. This is a person who will not stop, who doesn't agree that court orders apparently apply to him, who doesn't agree that when the court says no contact, it actually means it, who doesn't appear to understand that he cannot continue these aggressive tactics because it is criminal. He will not stop. When someone does not stop and will not stop and has a history of disregarding court orders regarding contact, tries to be careful in crafting his language in the dozens or hundreds of emails he's sending so he's not accused of threatening someone despite doing exactly that, they remain a danger to the community and must be removed from it as long as possible. The aggravated stalking charge is a 2 to 15. The maximum possible penalty for that crime is 6 to 15 years. That is the state's request, because this defendant has demonstrated he will not stop. He cannot stop, and he will disregard any of the orders that this court provides him. We've also indicated we would like no contact, and that's in the guilty plea, with your family. Any contact with the children should be ordered through the family court. Javier Cardona, Jason Elliman, Risa Bhakta, Brianna Lamana, and these no contacts ordered had to be extended to not just these people, but their family, friends, and neighbors, based upon the history of abuse that has been demonstrated throughout the long and tortured history of this case. This defendant has 480 days credit for time served.
Thank you. Mr. Bellisario, is there anything you'd like to say before your attorney speaks for you?
Yes, Your Honor. I don't know where to look. I'm sorry. Thank you for allowing me the time to address this court. I'd like to start by offering my sincere apologies to Ms. Cardona, Mr. Elliman, and Mrs. Lamana. I realize that my actions affecting Ms. Cardona, Mr. Elliman, and Ms. Lamana were unacceptable and wrongful behavior. Threats of physical violence are never okay and nothing I will ever do again. My behavior during these events is not how I'd like to protect myself to anyone, especially my family, my children, and anyone involved in my children's lives. Those who know me know that in my right state of mind, I would never intentionally attempt to install fear in anyone. This court has already accepted that my behavior during the events related to alcohol use. I believe it's obvious that mental health issues, along with substance abuse issues, affected my behavior during the events. I understand that sentencing is solely up to the discretion of this honorable court. I request your leniency and for your honor to consider co-occurrent specialty court to address my underlying mental health and substance abuse issues while allowing me to become a productive member of society, allowing me to pay restitution, and allowing me to pay child support, all under this intense supervision of the court. As your honor is aware, I have been accepted co-occurrence court and received a letter of appropriateness stating that the program is appropriate given my charges in medical history. I understand if granted probation, I would be on the thinnest of ice, but the last year in custody has shown me that it's not a lifestyle for my future, and I'm motivated to follow the rules by the letter. Lastly, I request your honor to consider the child custody issues intertwined in this matter. I have not been allowed any contact with my 3 young children for over 3.5 years simply because the case is over. That is a departure from the norm that I have personally witnessed, which promotes the state of Nevada's policy of ensuring minor children have frequent and meaningful contact with both parents. The withholding of my children has been a very coercive effect during this matter and has been the worst punishment a parent can imagine. If granted probation, I would immediately be able to exercise visitation rights and be reunited with my children. I would just also like to point out, I've had no contact with the victims since 2021, so there's no ongoing threat. I followed all the rules of supervision with high-level house arrest. And I don't believe I ever said that it was my ex-wife's fault, my actions. I was just trying to say that we were in a toxic relationship and there was an effect on my mental health, but I never said it was her fault. So, thank you.
Thank you.
Thank you, Judge. So I'm flipping through Mr. Bellisario's PSI. You do have a copy, correct?
Yep, right in front of me.
I'm seeing it's 0 felonies, 2 misdemeanors, minor misdemeanors, and he's going to be turning 40 this year. This is not a career criminal. This is someone who had a small mental issue. Now, I don't want to say this case is personal for anyone because that's not the right word, but is definitely familiar for people because it has gone on for so long. And I believe because it has gone on so for long and there's a familiarity there might be a little emotional resonance, which is not fair to Mr. Bellisario. We've had other people who almost exact same thing, not exactly, but you understand, but because we see him in and out. Yeah, thank you. We see him in and out so quickly. It's like, okay, boom, check, done, see ya. He should be treated like any of the other ones who it's not as quite familiar. We shouldn't let the familiarity affect any punishment on him. And I also appreciate that one of the alleged victims, and I'm only saying alleged because that is the victim is going to speak in this case by agreement, but it's in a different case, which has not been adjudicated at this point. She is a district attorney. It's the same thing. We shouldn't give anything she says more weight or more emotion just because we see her once a week. Some people see her every day. She should get the same weight as any other victim, where at times you will still say, I understand, but it's probation. And it is the one victim speaker. I believe it is a misdemeanor that she will be speaking on. I'm also going to point out, even though there's the familiarity and the emotional resonance, to my knowledge, Mr. Bellisario has actually never hurt anyone. I believe there was one domestic, physically hurt anyone, possibly emotionally. I understand that, but there is a difference. Everyone's like, he's so dangerous. But if you look at this, he's almost 40, and to my knowledge has never caused physical harm. I believe there was one domestic violence charge against him, but I believe that actually went through trial at municipal court, and he was found not guilty. I don't know exactly because I don't have the notes. He's correct.
It was dismissed, but she showed up to go forward with trial, but they dismissed it.
Okay, it was not tried, but the city of Las Vegas decided to dismiss it, even though they had their witnesses there. I don't know why the city did, but he was also on monitoring for 2.5 years and on the outside. He did not hurt anyone when he was outside. I know he had the argument with his attorney where she actually said, no, I never felt physical threatened, but I did feel threatened for my career and things like that, which we say is not acceptable. But as he just brought up, he lost his divorce case simply because he was in custody and his prior attorney never filed a motion at justice court to say, hey, you need to be out. They kept him, you can do this on the Supreme Court website. They kept him in for an additional 6 weeks. They took a default against him in family court. He filed his own appeal. Some of the things the Supreme Court actually said, Mr. Bellisario, you're right. We're going to reverse on that. But the fact that he never showed up, they didn't reverse that when they're like, sorry, she still wins by default. I think if an attorney did that to any of us, we would be a little overcautious with any other attorney if we don't feel like they're doing the things that they should be doing. So I can understand some, hey, why aren't you doing this? If this was any other client, I would right now be asking for co-occurring court. I would still ask for co-occurring court. I would still love it, but this isn't my first rodeo, and I know you will do what you believe is right, but based on your previous rulings, I don't think you're going to agree to co-occurring court. However, when I did file my motion to set aside based on his mental health, even you acknowledged, yes, when he first signed this guilty plea agreement, I didn't see anything. He seemed perfectly fine. But when you've seen him in the court since then, you've acknowledged that, yes, it looks like he has some mental health issues. I previously sent you very brief documents included on the motion to set aside, talking about what someone briefly looked at him thought his issues were. Since then, his family got me more documents, and that is what I submitted to you 2 weeks ago, which actually confirm those diagnoses, okay? I appreciate that he is better groomed and a little more educated than some of the other people we have in here with mental health issues. But if he got the crazy beard going and looked like he didn't bathe often enough and wasn't well-spoken, it would be easier to say, oh, he has mental health. We need to put him in co-occurring. Yeah. But because he presents himself better, oh, does he really? Also, we know he has a substance abuse problem. As I said, he has 2 misdemeanors. One is a DUI. And then also, I believe that when all of this was going on, the serious issues that this stemmed from, he was self-medicating on some controlled substances. He has been accepted to co-occurring court way before I got involved in this. However, while I would love co-occurring court, based on what I've seen your previous rulings, I don't expect you to do that. I would think it would be the right thing, but I don't expect you to do that. I would ask for 2 to 5 years in prison, which seems like it's on the bottom, but that's what the policy is. If we had someone with his record, he is 40 years old, no felonies prior, he did have, boom, this spree, if you want to call it that. What do you do if we have an identical case to Mr. Bellisario's in another year, but we look and, well, this guy's had 3 felonies already or 2 felonies already. Do you think it's just? Do you think once the system is to give Mr. Bellisario the exact same sentence that you would for someone for 3 years? Maxing him out goes against what the judicial system is. And again, I realize this is familiar and we've seen him for 5 years, but he has to be treated just like you would treat any other defendant in this courtroom. And I do not believe any other defendant would be getting, I don't even think the state would ask for most defendants to have the max based on his clean record. He's never going to practice law in Nevada again, but he might be allowed to go live with his parents in Chicago and work in some legal way where he can actually accumulate money and pay back this money to the restitution that the state is being asked for. Again, I don't think anyone here says he would accept responsibility based on seeing things. He is accepting responsibility. And he is vocal. If he believes something, he will say it. If he doesn't believe something, he's not holding back. He is accepting responsibility. Again, I think you're going to send him to prison. That is we want to punish. We want to rehabilitate. That time in prison will be the punishment. We don't need to keep him in forever. He is no more of a danger community than anyone else who gets the benefit of probation. And he does have parents who are flying out here. They're here right now, which I believe would agree in a heartbeat to take him back to Chicago and have him live with them for the next freaking 3 years, if you would be somewhat inclined. I know we can't order anything like that, but I think that's what the plan would be. Did you have any questions, Your Honor?
No.
Okay. Thank you.
All right, thank you.
The state would like to call Brianna Lamana.
You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Can you please state and spell your first and last name for the record?
My first name is Brianna. My last name is Lamanna.
Thank you.
Speaking in this case is incredibly difficult for me. I think anyone who knows me would agree I'm a very strong-willed and stubborn person, so it's hard for me to admit that Mr. Bellisario had an impact on my life. I want to stand here and tell him that he hasn't had an impact on me at all, but that's simply not true. Due to Mr. Bellisario's actions in this case, I have dealt with massive anxiety and fear for years. I eventually enrolled in therapy last year in part to deal with what happened to me in this case and help to get a hold on my anxiety attacks while I was in court trying to do my job. I want to start by explaining what happened in my case. On July 30th, 2021, I was working like any other work day. It was a Friday and I had to leave early to take my 1-year-old son to his first dentist appointment. At the time, I was assigned to the domestic violence team, and I received an email from Mr. Bellisario around 1:30. That struck me as odd since I was prosecuting Mr. Bellisario for stalking his wife, and at the time he was represented by Mr. Goodman in the criminal case. I briefly read over the first part of the email where he was threatening to institute another civil suit against me and that he requested that I send him $100,000 to avoid that civil suit. At that point, I rolled my eyes and forwarded the email to my bosses and the civil division of our office as they were representing me in the civil case. Just a few minutes later, after I forwarded the email, I got a call from one of my bosses, Robert Daskis. He was calling to check on me because he was concerned after reading the email. I asked him to clarify why he was concerned, and as he did so, I pulled up the email again and read it all the way to the end. That's when I saw that after Mr. Bellisario tried to extort me for $100,000, he ended the email with "Good luck with your kid." As a new mom, my stomach immediately dropped. And I thought through, how could he know that information? And what did I do wrong that he would have that information? I will never forget that feeling. As a prosecutor, I have often seen what people are capable of on their worst days. But it's a different feeling entirely when a person's bad actions are aimed directly at you and when you and your family become the target of someone's anger. I left the office shortly after receiving the email to pick up my son. I spent the 30-minute drive trying to calm myself down and thinking through all the worst possible scenarios. As I arrived to pick up my son, I realized I didn't know what kind of vehicle Mr. Bellisario drove and that there was a vehicle that had followed me into the neighborhood of my son's caregiver. Due to my fear, I had to have his caregiver walk me and my son to my car because I was terrified Mr. Bellisario might have found me and my son. I was shaking the entire time I took my son to his appointment, constantly looking over my shoulder, worried that the defendant might know where I was. As I tried to fall asleep at night, I was still terrified. I realized that because we had just moved into a new house, my address was not blocked from public view. I spent most of the night anxiously thinking through every possible thing that could happen and jumping at every small noise I heard. Around 9:30 that night, Bellisario, the victim in this case, the case that I was prosecuting, reached out to me to let me know that she was concerned for her own safety because the defendant had spent the entire day reaching out to her friends and was making unhinged comments to them. Of course, she had no clue what I was going through, but it only added to my massive anxiety, for I had seen what he could do when he was angry and unhinged. I worried he might show up to my house the way he had showed up to his dad's house and destroyed their belongings. I knew what he was capable of, and I was terrified. My anxiety and fears did not calm for several months. I was able to get a good security system and block my address, which helped a little, but I was constantly worried that he would find me and my family, and I was worried about what he would do. Then once I was a charged victim, I could no longer help the case. And because the defendant had numerous criminal cases in the courthouse, I continued to run into him. I've ended up in the elevators with him numerous times, and it seemed like every time I had a case in this department or in District Court Department 17, defendant would be in there as well. Each time I'd seen him, I had an anxiety attack and I felt on edge. I was constantly texting my family and friends, just so frustrated that I continued to run into him. It would take hours for my body to calm down and to convince myself that I wasn't in danger. Since the defendant was a barred attorney, I also worried that he could easily get access to me through the security in the building I worked in. I was constantly on edge until I found out that he was back in custody, and then I could breathe a little easier. My incident is just a small portion of the defendant's cases. I am just one of his numerous victims. My terror and anxiety is nothing near what I know Emily and her loved ones have suffered through his actions. But his one statement, his one sentence to me has put me on edge for several years. His actions throughout his numerous criminal cases have impacted all of his victims greatly, and that impact will likely be felt for years among his numerous victims. I think the worst part of everything is that Mr. Bellisario has done this while he was a barred attorney. I know that attorneys are people just like everyone else, and that obviously we all have our flaws, but we are also held to a higher standard. We take an oath to treat each other with civility. And Mr. Bellisario knew better. He knew the law. Each and every time he made the conscious decision to break the law and commit a new crime. I understand that his crimes weren't violent, but they certainly had an impact on all of his victims. They were meant to terrorize us. He knew what he was doing, and he chose his words wisely when he used them. He knew exactly what he was saying in wishing me luck with my young child and the impact that that would have on me as a new mother. I know Mr. Bellisario has mental health issues, and I'm often sympathetic to that when I negotiate cases. But Mr. Bellisario has been suffering from his mental health and substance abuse issues for over 5 years at this point. He has had numerous opportunities through the court system, both in criminal and family court, and through resources at the Nevada Bar to address his issues, and he has chosen not to. He has continued on with his behavior, picking up new cases after threatening me and my family and continuing to make threats to those he feels have wronged him. Based on all of this, I truly believe the community needs to be protected from Mr. Bellisario. He has already shown he cannot be out and behave well on supervision, so I don't believe he should be given probation. I ask that this court sentence him to the maximum sentence of 6 to 15 years. I think that that is the only way the community will be protected for the longest period of time. Thank you.
Thank you. Well, there's certainly no disagreement that this has been a long and very difficult case. My first experience with this case and Mr. Bellisario was after this incident with the DA, and the motion was to release him from custody and give him a chance to be on house arrest. And it was my observation at the time, as Mr. Bellisario mentioned here today, that it appeared to me that when he wasn't drinking, self-medicating, and was following his doctor's orders with regard to medication, he seemed to be stable enough to not pose a threat. And I believe it was over a year that he was out of custody on house arrest without incident. However, he came in several times asking to be taken off of Scram, and I refused because, again, that was to help him make sure that he didn't self-medicate. Despite that, he chose, while he was stable, presumptively sober, because he was on Scram, they would have known, to either stop taking his medication or whatever happened, and he ended up with the situation with his attorney that we had. Again, with the threatening emails, I'm going to sue you, I'm going to get you disbarred, I'm going to take your license. And what was very interesting to me when we had that hearing is that he made sure that I knew I never physically threatened her. I didn't physically threaten her, which sent me a very clear message. This man understands what he's doing. And he lets himself go into the psychotic episodes by choosing to self-medicate and by choosing to not take his medication when he needs to. I have read all the letters, and I understand he has a loving family. I understand he has people in his life that see that there's a man there with a heart that has a good side, that was an amazing friend as a child, that it was an amazing child to a parent. And I don't believe that person is gone. But for some reason, his choice to not stay stable when he does have access to the health care that he needs is an extreme concern to this court. And I am taking into consideration that despite all the threats, and some of them extremely violent, threats of death, he has never actually physically harmed any of his victims. But he has physically harmed personal property, and we all know that often in these cases, that's the first stage of an escalation or the second stage of an escalation. And that is why everyone is so concerned. I have a letter from Katie where she says he does not believe that he's getting the care and support that he needs. If he's not getting the care and support that he needs, it's because he's choosing to walk away from it. And again, that is the concern of this court. It's been my position since the first time I had him in my courtroom that if he does take the medication, if he doesn't self-medicate, if he's not drinking, that he can be stabilized. My concern is that he chooses over and over again not to. I have information and medical records and letters from his marriage and family therapist, Nikki Beecher, from 2000, all the way back from 2017. So now it's 2025, 8 years he's had access to mental health care. 8 years he's been diagnosed with anxiety and other issues. And they seem to be getting worse if you follow the medical records. Now it's PTSD and other severe issues, not just anxiety and depression. So he's getting worse and choosing not to seek, or he seeks help, but then he won't follow through with it on a consistent basis. So we actually have records from 2017. All this time, he's had access. He has a family that loves him. I have the letters from his dad and his stepmom, financially willing to support him, emotionally willing to support him. And he takes it for a while and then he walks away. And that is the concern. So based on that, I do believe he's stable right now to the extent that he is, and taking the responsibility that he is, because he is in custody. And in custody, he has very limited options on whether he's going to be able to take his medication and not self-medicate. And that's what's keeping him stable. I have no confidence that if he gets out anytime soon, that that's going to continue. One other letter we have from one of his mental health professionals, let's see here, from Meadow Psychiatry. It states the symptoms seem to be relatively stable on his medication regime. That's the best they could do. Seem to be relatively stable. That's a concern. This is a letter of support asking me to put this person back into society. So it just spoke to my concerns, and I think everyone's concern who has spoken in this room, and everyone who's written letters, including his family and friends, that this is a person that was a wonderful, loving man, that at one time was a wonderful father, and has had some setbacks, some difficult times in his life, and his reaction to that was very bad. And not just for a few months, years and years now, that he, without a very strict regime like in prison, will not choose to be the person that he can be, to be the best version of himself. Instead, he chooses to allow himself to continue on a path of threats, intimidation, fear to anybody who he decides is in his way. And with everything that's in front of me, I have zero confidence that that's not going to continue if he doesn't stay in prison. However, I do think the fact that he, one, physically never actually hurt anyone, that whatever measures he did take to seek help and to stay stable, they were enough that he didn't physically hurt anyone, that he has made efforts, even though they come and go, and that he has no other criminal history. I think the maximum would not be appropriate. So in accordance with the laws of the state of Nevada, the court does now sentence you to confinement in the Nevada Department of Corrections for a minimum term of 4 years with a maximum term of 10 years. You are also ordered to pay $16,400 in restitution to Elijah Lee. You are also ordered to have no contact with, and state, I'm going to ask you to list all of those victims again, and this will include their family members and their neighbors.
Javier Cardona, Jason Elliman, Risa Bhakta, Brianna Lamana.
Thank you. You'll be given 480 days credit time served and assessed administrative assessment fee of $25, a DNA fee of $150 if not already taken, a DNA administration fee of $3, and an indigent defense fee of $250. And I also want to state that Mr. Bellisario, I think that you are going to get help you need if you choose to accept it while you were in prison. I think that the 4 years with 480 days credit time served already is going to give you enough time in prison that you can truly stabilize if you choose to, and that you can make the decision to continue to keep yourself stabilized when you get out. I hope that you are reunited with your children once you get out, because I do believe, and our Nevada Family Court rules and laws support this, that we believe the basis that we start with is that the children need both parents in their lives, but not if the parent is going to hurt the children or be a bad influence. And I believe that you can be the dad that you were in the beginning and the dad that you want to be. And I think you can be the man that you want to be, but you're going to need a lot of help. And I don't think you're in a position to make those decisions right now without the help that prison's going to provide. So I
Can the
don't think we
court
have
also
anything
issue-
further.
Can the
Mhm.
court issue an order that based upon the court ordering that $16,400 to Elijah Lee, the state will now have to dismiss 23 CR 009122?
All right, and with the order of the 16,400 in restitution to Elijah Lee, the state must dismiss case number 23 CR 009122. And also, Mr. Bellisario, please keep in mind that because of this plea negotiation you entered into, there are numerous other cases that are either not being prosecuted or being dismissed. So the good part of this is that once you are released, you're free from all of this. There's no more charges pending over you. There's nothing else to frustrate you and aggravate you. The only thing you have to do is work on getting well in prison, and when you get out, work on staying well so you can be there for your friends and your family and your children. Thank you.
Your Honor, one last housekeeping.
Sure.
I've spoken with Mr. Bellisario. He is considering appealing some of the rulings in this matter. He does think it's appropriate for a different attorney other than myself. I am fine one way or another, but for his wishes, for the office which retains me to represent other people, if you order a different attorney do the appeal, it would be easier to get a different attorney, most likely.
All right,
So,
yes, I mean, any appeal is probably going to have some ineffective assistance of counsel issues, so he's going to have another attorney. So to the extent that if Mr. Bellisario, you feel that would be appropriate, I will order that a different attorney be assigned to you. We may have to have a hearing in the future as to who that can be because of how many attorneys you've already had, and we need to make sure we do conflicts checks and such. Also, I absolutely do not discourage you at all from exercising any legal right that you have. But on an emotional level, I would like to encourage you to consider getting the help you need while you can in prison and putting all of this behind you. All right. Thank you.
thank you, Your Honor.
Is his other case dismissed as well?
Yes, the one in here.
Yeah, let's call it, I guess, and then the state can dismiss it.
Calling page 10, C 362447, State of Nevada versus Bradley Bellisario.
Based upon the fact that the defendant has now been sentenced, the states are asking that this case be dismissed.
And the case is dismissed. Thank you.